Hi, I'm Eddie Chase, and welcome to another edition of Prosecutor Brief. Today we're going to be discussing how to effectively present your forensic interviewing expert during the course of your trial. One of the main things that you are going to use your forensic interviewing expert for is to educate the jury. Keep in mind, forensic interviewing concepts are things that are completely foreign to almost all jurors. It's going to be important that you use your forensic interviewing expert to educate them and let them into the world of knowledge that we know is the basis of forensic interviewing. One of the things you're going to have to do before you even get to that point of presenting your forensic interviewing expert in trial is to become a mini expert yourself. You need to be able to understand the basic concepts of what forensic interviewing is, and there are great resources out there to help you with that. The National Children's Advocacy Center's Child Abuse Library Online, known as CALIO, has a wonderful world of resources available to you at your fingertips to help you become that mini expert. It's important because you're going to need to know what the expert is talking about on the stand to be able to know whether or not the jury is fully understanding and grasping what they're talking about. It's also going to help you to have a more in-depth conversation with your expert prior to getting on the stand so that you can understand, are there any issues that are present in this forensic interview? And if there are, how do we effectively communicate that to the jury? And while if you look at the interview as a whole, it is still a reliable interview. One thing that you also need to remember is don't expect that the forensic interviewing expert is going to be able to clean up your case. You have to be able to present your case effectively up until that point. And then when you're questioning your interviewer, make sure that you're getting out all the information that you want to get out from them. Don't assume that they're going to be able to just clean up and fill in the blanks for you. And that's another reason why you need to become familiar with basic forensic interviewing concepts before you present them at trial. Review the testimony before trial. That may sound silly, but it's important that you have a conversation with your forensic interviewing expert and you discuss what the limitations may be to their expertise. Some of the common objections that you may get are that maybe a forensic interviewer is not an expert in forensic interviewing or in other concepts that you may want to talk about. Let's say you want to talk about child development and the child's brain development. Well, your forensic interviewing expert or your forensic interviewer may or may not be an expert in that particular field, so you need to know whether or not they are going to be able to adequately discuss that at trial. Now, when you get to trial, don't just begin the forensic interviewing testimony during the course of the testimony itself. You actually want to start before that, in your opening statement. In most jurisdictions, prosecutors are allowed to discuss what they reasonably believe the evidence is going to show, and that includes what experts are going to say. So now that you've become a mini expert, you can adequately start to educate the jury as to what your interviewer is going to say on the stand. Start talking about concepts of suggestibility, coaching, and why the expert is going to tell you that those concepts don't even apply in this particular case. So before they get on the stand, everything that the jury is going to hear, they're going to be interpreting through the things that you've already let them in on during your opening statement. And when they do finally testify during their testimony, the expert's going to be able to hammer home those points even more. Qualifying an expert. If the defense has an expert, never accept a stipulation as to their qualifications. Always make sure that you go through and you demonstrate to the jury why your expert is the one who's the most believable and has the best credentials. So you're going to want to have your forensic interviewing expert talk about the various parts of the forensic interviewing protocol while they are testifying. Start out and talk about rapport building. Why is that important? It's not just chit-chat. There's actually research behind that. And go through each stage of the forensic interviewing protocol to talk about why the research shows that each stage is important. The rules section. The rules section is extraordinarily important to talk about. The promise to tell the truth, and that research shows that if a child promises to tell the truth, then they're actually much more likely to do so. Or when the interviewer says, I want you to correct me when something is wrong. That's not just them being nice. That's a really important tool, giving the child the ability to say to this adult, if they get something wrong, I have permission to correct them. That's really important because, again, it increases the likelihood that the information that we are getting from the child is correct information. Narrative practice. Again, it's not just they're making small talk with the child. There's a valid point to all of these aspects of the forensic interviewing protocol. Don't be concerned about flying through this section. It's more important that you have the jury understand that each of these parts is extremely important. Your expert doesn't need to be familiar with every single research paper that's out there, but they do need to be familiar with at least the major ones that discuss the concepts that you want to hammer home. You can also use your interviewer to combat common myths that are out there, such as abusers are rarely known to the children. We know that the majority of abusers are actually family members or close family friends. Have them talk about that. Have them talk about what the research shows that children a lot of times don't tell, or they minimize instead of making things up. Base it in the research, but have your interviewer talk about all of these things so that the jury can truly understand and we can start to combat some of the myths. And in closing, what you're going to want to do is you're going to want to talk about the concepts that the interviewer has talked about. The biggest one that I want you to think about is contextual details or sensory details that your interviewer may have discussed during their testimony. Things like what the child felt, saw, tasted, etc. These are things that it's almost impossible for a child to just dream up. These are the things that let us know, and this is what we want to argue to the jury, is this is how we know that this child is telling the truth, because of the context that was able to be brought out during the course of the interview. So have your interviewer talk about that. And then in closing, make sure you hammer upon those really important points. One other thing before I let you go, while it's important to discuss the basic concepts that are out there, don't bring up concepts unnecessarily. Don't muddy the waters unless you think it's something that's going to be brought up by the defense. There's no point to bringing up suggestibility if the child is a 16-year-old, because suggestibility wouldn't necessarily apply to a child of that age. So don't necessarily muddy the waters unnecessarily, but it is important to combat things that may be brought up by the defense. Until next time, thanks for watching.
Thank you for watching this episode of Prosecutor's Brief. If you have questions or comments, see the contact information listed below. If you'd like further information, please check the links to Calio, the NCAC online library, and other resources listed. As always, thank you for the work you conduct each day in protecting the children in your community.